He married my money, but he underestimated me. I was born into wealth, not loud wealth, not flashy wealth, structured wealth. My father built commercial properties across the city. My mother managed private medical facilities. Money in our family was a tool, never the goal. So when I met Daniel in graduate school, I didn't see risk. I saw ambition. He wasn't intimidated by my background. He didn't ask about my family's holdings. He didn't comment on the car I drove or the vacations I'd taken as a child. That's what made me trust him. We dated for 2 years before getting married. He insisted on a modest wedding. "I don't want people thinking I married you for money," he said once, half joking. I thought it was romantic. Looking back, it was strategic. A year after our wedding, my father transferred partial ownership of a shopping plaza and 3 rental buildings into my name. It was a wedding gift, though it came later for tax structuring reasons. Everything was legally mine. Daniel offered to help manage it. "You shouldn't have to stress over contracts and tenants," he said. "Let me handle the operational side." It felt supportive. It felt loving. It felt like partnership. So I agreed. At first, he simply reviewed lease agreements and communicated with property managers. Then he suggested forming a holding company. "It's cleaner for liability purposes," he explained. "Trust me." I signed the paperwork. I didn't read every clause because I trusted my husband. That was my second mistake. Over the next year, more documents appeared. Refinancing agreements, updated operating structures, board restructuring. Each time, Daniel would summarize, "It's just optimizing tax exposure. It protects you. It simplifies everything." And I signed, sometimes late at night, sometimes between meetings, sometimes without even sitting down. He was my husband. Why would I doubt him? The first crack appeared when a banker called me directly. "Mrs. Carter, we need confirmation regarding the asset-backed restructuring." I frowned. "What restructuring?" There was a pause. "The commercial plaza was transferred under Carter Holdings LLC 6 months ago." Carter Holdings. That was the company Daniel created. The one he insisted was just administrative. "Who is listed as majority owner?" I asked carefully. Another pause. "Daniel Carter. My husband, not me." I didn't confront him that night. I didn't scream. I didn't accuse. I opened every folder in my home office instead. Digital copies, email trails, signatures. Slowly, carefully, I pieced it together. The holding company I signed into existence had a clause buried deep within its formation documents. Operational control automatically shifted upon restructuring. Restructuring he initiated. Papers I signed. Properties I thought were protected. Legally. Redirected. It wasn't theft. It was consent. Engineered consent. And that's what made it brilliant and terrifying. When Daniel came home that evening, he kissed my cheek and asked about dinner. I looked at him differently. For the first time, I didn't see a husband. I saw a strategist. And I realized something chilling. This hadn't been impulsive. This had been planned for a very long time. The debt I never approved. The next morning, I didn't mention the phone call. Instead, I made coffee, sat across from Daniel at the kitchen island, watched him scroll through his phone like nothing had shifted. "How's the plaza doing?" I asked casually. "Stable," he replied without looking up. "Occupancy is strong." Stable. That word now sounded artificial. Later that day, I drove to the bank myself. Not the branch we normally used, a private corporate branch. I requested full documentation tied to Carter Holdings LLC. The banker hesitated. "You're listed as a founding member," she said carefully, "but not as controlling partner." Controlling partner. That was Daniel. My pulse remained steady. "Any outstanding liabilities?" I asked. She turned her monitor slightly away from me. "There are 2 lines of credit secured against the plaza." Secured against my property. "For how much?" "Approximately $1.2 million." The room didn't spin. I didn't gasp. I simply stared. The plaza's value was over $4 million. He had leveraged it without telling me. That wasn't poor judgment, that was concealment. I drove home slowly, replaying every late-night conference call, every time he locked his office door, every time he said, "Trust me." He wasn't mismanaging, he was expanding risk, and I wasn't part of the decision. That evening, I opened his laptop. I knew the password. He'd never thought to change it. There were trading dashboards open in his browser. History. Private equity placements, high-risk development projects, speculative overseas investments. One email caught my attention. Additional capital required to stabilize position. Additional capital. That's what the loans were for. He wasn't protecting assets. He was gambling with them, not on crypto, on commercial development projects outside the country, unstable regions, aggressive timelines, high reward, catastrophic risk. I printed everything. Emails, loan documents, board resolutions. He had signed as managing director. I had signed as member. The structure insulated him personally, but tied the assets to corporate debt. Brilliant. If it worked, he'd look visionary. If it failed, the properties absorbed the damage. And because I signed formation documents, I had unknowingly allowed it. That night, I didn't confront him. Instead, I called someone I hadn't spoken to in years, my father's corporate attorney. Hypothetically, I said, if someone engineered control through restructuring without clear disclosure, what protections exist? There was a long silence on the other end. "Are we talking about your husband?" he asked quietly. "Yes." Another silence. "Bring me everything." The next week was quiet. Daniel behaved normally, even affectionately. He booked dinner reservations, spoke about future expansion. "Once the new development matures, we'll double the portfolio," he said one evening. Double. He was already leveraged beyond safety and still pushing further. I watched him carefully. He didn't see fear in my eyes, because there wasn't any. There was calculation. The attorney's analysis was cold, precise. "Technically, you signed," he said, "but disclosure language is questionable." He tapped one page. "This clause here, It allows operational authority transfer without explicit asset retitling notification. In plain English, Aikitsi asked, he buried control in legal language you are unlikely to scrutinize. Is it reversible? With evidence of deceptive inducement? Possibly. Possibly was enough. 2 weeks later, the first investor default notice arrived. One of Daniel's overseas projects had stalled. Construction delays, political complications, funding gaps. The line of credit secured against the plaza would need restructuring. Translation, more borrowing, or asset liquidation. That's when I finally confronted him. I placed the default notice on the kitchen counter. He stared at it, then at me. You went through my documents, he said. Not, how did you get this? Not, we need to talk. He was angry about access. Why is my property collateral for a foreign development project? I asked calmly. It's strategic leverage, he snapped. You wouldn't understand. There it was. Condescension layered over risk. I understand enough, I replied, to know you never told me. It was implied. $1 million obligations. Implied. That was the moment clarity replaced doubt. This wasn't partnership. It was appropriation. He didn't marry my money. He married my infrastructure. And slowly, deliberately, he absorbed it. He thought he controlled everything. After our confrontation, Daniel became careful. Too careful. He stopped discussing investments openly. He locked his office again. He started watching me the way I had been watching him. Suspicion had entered the house. But here's what he didn't understand. I wasn't reacting emotionally. I was repositioning legally. The attorney moved fast. We don't accuse yet, he advised. We isolate. Isolate meant freezing exposure. We filed a formal request to review corporate governance under fiduciary obligation clauses. Daniel didn't expect that. He thought my silence meant ignorance. He forgot I grew up in boardrooms. At the emergency board meeting, held virtually but legally binding, I invoked a minority protection clause, one he never thought I'd use. Under state corporate law, any managing director accused of self-dealing must provide transparent disclosure. His face changed when the notification arrived. You're overreacting, he said that night. I'm protecting myself, I replied. You signed everything. Yes, I said calmly, but you summarized it dishonestly. There's a difference. The forensic accountant's findings were brutal. Daniel hadn't just leveraged the plaza. He had pledged 2 rental properties as secondary collateral, and the overseas development he invested in, it was bleeding cash, not temporary volatility, structural failure. If the project collapsed fully, creditors could seize the plaza, my father's wedding gift, my financial foundation, gone. Because my husband wanted to prove he was a visionary. The next move was surgical. We petitioned the court for temporary injunction on asset transfers under suspicion of fiduciary misconduct. Daniel received the notice at his office. He called immediately. You're taking this to court? You took it to leverage, I replied. His voice shifted from defensive to pleading. I was going to tell you when it stabilized. When? After foreclosure? Silence. He had no timeline because he had no control, only hope. And hope is not a financial strategy. The court granted temporary review authority. That meant no further borrowing, no asset liquidation, full disclosure of offshore transactions. For the first time since our marriage began, Daniel didn't control the numbers. I did. That evening, he tried a different tactic. Emotion. I did this for us, he said softly. I wanted to build something bigger. You built something secret, I answered. Don't throw away 8 years over paperwork. It wasn't paperwork. It was deception layered in legal language. He hadn't made a mistake. He had made unilateral decisions with shared consequences. That's not ambition. That's arrogance. The investors pulled out within a month. The overseas project collapsed. Daniel's leveraged position unraveled quickly. Without additional borrowing, blocked by court order, he couldn't stabilize the debt. The restructuring forced partial liquidation. But because we intervened early, the plaza survived. Barely. He lost his development stake. He lost external credibility. And, most importantly, he lost control. He moved into the guest room after that, not because I asked him to, because power had shifted. When financial transparency becomes mandatory, manipulators shrink. He started sleeping less, eating less, checking markets obsessively. But the markets were no longer his battlefield. The courtroom was. Divorce wasn't filed immediately. That surprised him. "You're staying?" he asked once. "I'm observing," I replied. Observation is uncomfortable for people who rely on narrative control. He couldn't spin this story. The documents were too precise. The final board resolution stripped him of managing director status, not permanently, but indefinitely pending litigation. His signature authority was suspended for a man who defined himself by financial dominance. That was devastating. And yet, I didn't feel victorious. I felt clear. Clarity is colder than revenge. I didn't scream. I didn't humiliate him. I simply restored structure, and in doing so, I removed him from it. He thought I would forgive him. After the injunction, after the board suspension, after the collapse of his overseas gamble, the house became quiet, not peaceful, strategic. Daniel stopped arguing. He stopped defending himself. He started negotiating. That's when I knew he understood. This wasn't temporary. One evening, he came into the living room holding a folder. "I've been working with a consultant," he said carefully. "We can rebuild, slowly. I'll give you majority control. We can recover. Recover from damage he created." "I don't want recovery," I said. He frowned. "I want stability." "Stability requires trust," he replied. "No," I corrected. "Stability requires transparency." And transparency had already failed. The divorce filing was clinical. No dramatic accusations, no emotional language, irreconcilable breach of fiduciary trust. That phrase mattered. It framed the separation not as emotional collapse, but structural violation. He didn't fight immediately. Then he did. His attorney argued that I signed willingly, that I benefited from early gains. That risk was inherent in growth. The judge disagreed because disclosure wasn't symmetrical, because operational summaries weren't complete, because marriage does not equal silent consent. Financial mediation lasted months. Daniel wanted partial operational return rights. I declined. He wanted equity participation in future expansion. I declined. He wanted to keep things amicable. I kept things documented. When the final settlement was drafted, the numbers were precise. The plaza remained under my direct authority. The rental properties were retitled, corporate control permanently restructured. He retained personal liability for the failed development, not because I punished him, because the paper trail showed initiation under his direction. That distinction saved me. The day the divorce finalized, he looked older, not broken, just exposed. "I never meant to hurt you," he said outside the courthouse. That sentence fascinated me. Intent does not erase impact. "You didn't think you would get caught," I replied calmly. He flinched. Not because I yelled, because I didn't. Silence is more unsettling than rage. 6 months later, the market stabilized. The plaza increased in value. Tenant occupancy improved. Revenue streams normalized. Without leverage pressure, without speculative gambling, without secrecy. The assets breathed. So did I. People asked what happened. I didn't explain details. I simply said, we had different definitions of partnership. That was enough. Because partnership is not dominance, not control, not manipulation disguised as intelligence. It is mutual visibility. Daniel didn't marry me for love alone. He married proximity to power. What he forgot is that proximity doesn't equal ownership. The last time I saw him socially was at a mutual acquaintances event. He approached cautiously. "I underestimated you," he admitted quietly. "Yes," I said, and walked away. Not because I hated him, but because I no longer needed him to understand. Here's the truth. He didn't steal my money. He tried to absorb my infrastructure. He tried to engineer control through legal language. He believed confidence would outpace scrutiny. But he forgot something critical. I grew up in contracts. I understood silence. And I learned quickly. He married my wealth. He underestimated my education. And when he leveraged my assets, he revealed his character, not through betrayal of love, but through betrayal of structure. And structure is harder to rebuild than emotion. I lost a husband. He lost authority. The plaza still stands. The rentals still generate income. The numbers still balance. But now every signature I place on paper is read carefully.